welcome to Newsclick. The Gujarat government has been consistent in its attempts to pass a strong anti-terror bill, having been failed previously 3 times in 2004, 2008 and 2009. Another similar bill, known as Gujarat Control of Terrorism and Organised Crime, has been passed by the State Legislative Assembly. To discuss the issue and the bill, we have with us civil rights activist Gautam Navlakha. Hello Gautam, welcome to Newsclick.
Hi.
Gautam, in a time where already acts like AFSPA, POTA, TADA have been misused, badly misused by Indian Army and police services, where do you think is the Gujarat Act going, and what do you think will be the consequences once it is passed?
First, I just want to say that all these draconian laws have not just been misused, but misuse is inherent in them given the nature of the power that is conferred on the police officers. Now, the Gujarat Control of Terrorism and Organised Crime Bill takes us further down the road of regulating and controlling and increasing the police's rights at the expense of citizenry. And I think that is the major problem with acts like this. It is claimed that Gujarat, or this new bill that Gujarat's legislature moved, is along the lines of MCOCA, which has been in operation for 15 years, which is true. MCOCA, by any stretch of imagination, is also a draconian law, and it's the way in which it has been used shows how flimsily and how sloppily police investigations have become in these heinous crimes which they are attempted to solve, and how in more than 70% of the cases the courts are actually coming out and acquitting the accused. The Gujarat bill differs from the Maharashtra MCOCA bill in couple of respects. It is same as MCOCA in terms of confessions made to a police officer not below the rank of or equivalent to a rank of a superintendent of police. That is the same. Which is not there in Unlawful Activities Prevention Act. It was struck down. So, the question that arises is that if a national, so-called national law has dropped a provision like that, why should you retain a provision which strikes and goes against everything that we have fought for and been against? The second thing is, as far as the interception of communication is concerned and its use as evidence, which is a very dangerous provision. We have seen how illegal tapping, illegal collection of so-called evidence through interceptions and all have time and again raised a question of the whole procedure that is allowed for these kind of illegalities, because you may begin your interception illegally, but retrospectively it can get legitimized by a senior officer okaying it and giving some very lame excuse to justify it. The third provision, which is different, which is actually different from the provision in MCOCA, is for bail. The bail provisions have become much more difficult and are more or less in line with the provision which existed for POTA, where it is near impossible to get bail because the prosecution has the right. It becomes a final arbiter when not the judge, not the trial court or any other magistrate, but the prosecutor becomes holds the veto right over bail, whether a bail should be granted. The last point, which is very scary, and in fact that is something that we should also be talking about and we should be mindful of, and it has a large, its consequences go beyond just this particular bill, which is that it has provided immunity, complete legal immunity to the state officers by saying in the clause 25, yes, that no prosecution or trial or any other legal process can take place against anybody who's supposed to have acted in good faith or intended to do something in good faith in accordance with the law. in pursuit of this law. This is a very dangerous, because it closes door. We know in this country that when even POTA contained clause 58 against malicious prosecution. So in case there was a malicious prosecution, there was a possibility for those who were victims of its abuse to proceed against or to prosecute those officers and police personnel who were involved in filing the malicious. This was dropped in Unlawful Activities Act. It has been dropped from the Gujarat Act, and as in AFSPA, so in this, it seems a complete impunity is being offered to police officers to carry out what they want to, and even if it results in malicious prosecution, fabrication of cases, planting of evidence, as we have seen in umpteen number of cases, the latest being the one about Liyaqat Ali Shah from Jammu and Kashmir, which the special cell in Delhi investigated and claimed that he was involved in some kind of a terrorist
I've been
plot.
repeatedly seeing all these things happening in Kashmir.
Correct. And the NIA itself came out with and established that this was completely concocted. Given all this, and given that in Gujarat in particular, if we should not forget, in May 16, 2014, the same day that Narendra Modi was being coronated as the Prime Minister, the Supreme Court was acquitting all the accused in the case of Akshardham. So therefore, it raises a much bigger question, that are we not using an argument about the heinousness of modern crimes like terrorism and organized crimes getting defined in such a way that it only targets crimes of one set of people, but overlooks completely the same or even worse kind of crimes committed by another set of people. So we are in fact kind of a, we follow, it's like we have not equality before law, that some people are more equal before law than the others, and in fact if you come from the majoritarian community, you will always be protected by law, because these draconian acts would never get invoked against us.
On the contrary, what the argument that the police and the army gives is, you cannot prove somebody guilty, especially those who are involved into such heinous crimes as terrorism, unless you detain them and you give them the sort of treatment they give when they are in police custody.
Our problem mounts, but India does not have any law which is in consonance with the Convention Against Torture. And India is a signatory, it has not ratified it, it ought to have done it by now. It hasn't done it. So therefore, if you have increased the period of detention to 180 days and you have increased police remand to 30 days and you allow for confessions before a police officer to be treated as well as against the co-accused, the same confession can be used against co-accused, then are you not actually encouraging torture? And since there is no torture is not a crime under Indian law, then you will allow everybody involved in torturing people in their custody to get away scot-free and evidence which is contaminated because of torture and because of being involuntary, and therefore not meeting the test that the Supreme Court itself has put. Is it not a grave threat that faces us?
Like we have seen previously in Gujarat, in a lot of states where Adivasis, where innocent peoples, even activists have been booked under all these acts and been kept in jail for years. Now, once proven innocent, let's say even after 20 years, like it happened in the case of Gujarat, how does the state justify all those 20 years for those who have been in jail for such a long time?
They don't. In fact, they are so brazen, they even contemplate going in appeal to challenge the acquittal because they believe that they are right. They will not accept that they are wrong. They don't even have, I mean, this is precisely the problem. I mean, if you empower the police and the security forces to a point, then the kind of fake encounters, of the kind that took place in Telangana recently, or in the border of Tamil Nadu and Andhra Pradesh just the other day, will keep on happening, and the police will justify its actions by saying that they acted in self-defense in opening fire and killing in cold blood poor people. And on the other hand, they'll also say that, well, they were only doing the duty, and if they are unable to get anybody convicted, it's because these terrorists are far more powerful than the Indian state is.
We know infiltration exists. We know terrorism is there. Cross-border infiltration takes place. We know there are sleeper cells existing, of which even the intelligence has barely any idea about. If not such draconian laws, which becomes the defense for all the police or defense services, what do you think is the other way to deal with such?
Before we jump to the question of whether terrorists or the threat of terrorism has increased or has reached a proportion where we have, where you need to come out with such acts as the Gujarat Terror Act or the Unlawful Activities Act, let's look at the reality also and the facts on the ground. The facts on the ground are that the infiltration which has been hyped up, one side of the mouth, this establishment always tells us that in Jammu and Kashmir things are reverting to normal, that the number of militants has declined, the number of infiltrations have been cut down in comparison to what it used to be. Even around the turn of the millennium, which ran into thousands, it's come down to 10s, 20s, 30s, 40s. So we have to be very careful also. I mean, when we talk about infiltration, yes, infiltration, there is infiltration, but is it of a kind that should arouse the kind of hype that is made out every time the government of India wants to use it to launch a propaganda and whip up hysteria against Pakistan or against its own so-called internal enemies? That is a question that we have to raise. I am not certain that the infiltration that takes place is of a nature or a magnitude that it has been hyped up into. It's exaggerated beyond recognition. I mean, when it ran into thousands, and if it has come down to 10s, 20s, 30s, 40s, there's a big difference. We have to recognize the difference. And if despite putting fences, electronically wired and electrified with patrolling and with sensors and everything, you can't prevent infiltration, then it just shows that security oriented policies are not adequate in addressing these problems. The second issue, how serious is the question of terrorism? It depends on how you define terrorism. There is no common definition of terrorism which exists across the board in this world. So everybody talks about terrorism. So what is terrorism? Is a bomb planted by a Bajrang Dal, Shiv Sena, or a right-wing member of which is a kith or kin of RSS or Shiv Sena, plants a bomb in a cinema hall? Is it an act of terror or is it not? Now, going by existing Indian laws, unless you invoke draconian law, it does not remain, it does not, despite the fact that it's a public place, civilians and unsuspecting civilians are being made a target, and tens of people will either die or lose their limbs. Is it not terrorization? Then why is it that our law allows such terrorism not to be counted as terrorism? Yet, it becomes a terror if you happen to be even a member or have been a past member of an organization. And even if you cease to be a member, that is a bigger crime than killing of people by planting a bomb in a cinema hall. The point I am trying to make is that the whole question of terrorism is also open to question. The way in which it is being applied, the second question is that if terrorism is a big threat to India, from where are we threatened most from? By present, I mean, going by evidence that is available to us today, we will find that actually the biggest threat we face is at the hand of the right-wing Hindu organizations which are fanatic and tied to RSS, which enjoy the state patronage, and now with BJP in central government in New Delhi, they are also protected. So it becomes a very difficult proposition.
Thank you so much for coming to Newsclick.
Thank you.